Hello and welcome to Alan History Nerd. In this video I am looking at the Supreme Court, in particular at public policy and the ideas of judicial activism and judicial restraint. I'm going to look at a series of examples from the Roberts Court to try and that can help you illustrate some of these key theories. How much action a Supreme Court should take on public policy is an area of big debate. This video is part of my playlist on A-level politics and also on my playlist on US politics. In terms of the A-level specification, what it tells us you need to know is in component 3A, section 4.3, the Supreme Court and public policy, the impact of the Supreme Court on public policy in the US with a range of examples, including examples post-2005, political significant debate on the role of judicial activism and judicial restraint and the criticisms of each. So I'm going to look at all of that. And this is probably the area where the Supreme Court stuff is at its most controversial, as there's a whole line of key areas of policy in the US which is very hard to get enough agreement to get stuff through Congress, and therefore often a lot of the key decisions on these issues are made by the Supreme Court. Now, whether that's a good or a bad thing, it is an area of debate. So I'm looking at significant judgments of the Roberts Court. So this is post 2005. Obviously, there are lots and lots of cases. I'm only going to look at a few of them. And the other bit is it says you have to have cases since 2005, but obviously there's loads and loads before that, before this time period as well. But there is obviously a limit to the number of examples and things that you can bring. Now, these examples should all give you some decent stuff to work with and give you a decent kind of idea of the kind of things the court makes decisions on and where the court is at the moment. So the first case I'm going to look at is DC versus Heller from 2008. This is to do with the Second Amendment, and it overturned a regulation in Washington DC that banned handguns in the home, and also had a requirement that rifles and shotguns had to be kept unloaded and disassembled, all of which was deemed to be unconstitutional. Now, the judgment was 5-4, which means the court was split. It's quite badly split. But it was seen as a really significant victory for the pro-gun lobby, although organisations like the NRA were a bit reluctant to get fully involved in it as it started because they were worried about it losing. But what it did is it set up, as now precedent in constitutional law, this idea of the right to bear arms for self-defence. And that was a particular interpretation that was taken by the majority view in the court, that self-defense is covered by the Second Amendment. Now, those who objected, who were Justices Stevens, Souter, Ginsburg and Breyer, argued the Second Amendment only covered the raising of militia, and therefore the self-defense argument, of reason why you'd have to have a loaded gun in your home, didn't stand. But they were in the minority view, and this, I think, is going to be a really important judgment going forward because it's set that precedent in a court case in the Supreme Court that self-defense is a reason why people are allowed to hold a gun in their home, and therefore it's going to make it very difficult for federal or state governments to do anything about it. Obviously, Washington isn't a state, Washington DC isn't a state, but that this law has already been spread further out, and it led immediately to the NRA and others challenging laws in different states. Citizens United versus FEC. Well, this is a key one to do with voting, so to do with campaign spending and its impact on voting. Now, it's to do with the First Amendment, and it revises regulation on the spending of money in elections, and it declared some aspects of the Bipartisan Campaign Reform Act to be unconstitutional. And Citizens United, which are a kind of conservative lobby group, who wanted to air an anti-Clinton film advertisement before the 2008 primaries. The 5-4 judgment, again, we see very much a split court. The judgment is hotly debated. On one side, this is seen as a great protection of First Amendment rights and a kind of the conservative take on it. On the other hand, it seemed to just empower wealthy lobby groups and essentially kind of explode the financial arms race of US elections, leading to largely unrestricted election spending, particularly by the super PACs. So again, a controversial one. First Amendment rights, obviously a really important issue to be dealt with by the Supreme Court. Election spending, something which, again, this is an important part, because we're seeing essentially the Supreme Court doing one of the things that it can do, which is overriding acts of Congress. And so this is the court being quite proactive in what it's doing. We'll look at judicial activism later on. The next case is the NFIB versus Sibelius, and this was to do with the Affordable Care Act, and it upheld the key aspects of the Affordable Care Act and the basis of states' rights in State Commerce Clause and the 16th Amendment. Again, it's a close call. It was a 5-4 judgment, but it upheld the provision that individuals be required to buy health insurance, and essentially this was seen as falling under Congress's power to raise taxes. The expansion of Medicaid, however, was overturned, and this is an area which it remained a major divide between the Republicans and the Democrats. And again, it's one of the things that you could argue has hampered Trump's attempts to overturn the Affordable Care Act when he was in power. Now, it's again one of those where you are, well, is this something that should have been left up to Congress? But this is more of a sign of judicial restraint, again, which we'll look at in more detail later. But because what the court has done here is it's upheld largely an act of Congress and has shown a degree of deference to Congress on that issue. Shelby County versus Holder. This is a 2003 case, and it overturned the Voting Rights Act of 1965. So here, this law was protecting. This judgment was protecting the rights of states to decide election laws, and stated that the 14th Amendment didn't support the act under the Equal Treatment Clause. Again, this is a hugely controversial act. Again, it's a 5-4 split. And the reason why it's so controversial is it can be seen as it making it easier, particularly for Republican states, to make it harder for minority groups to vote. Now, obviously, they would argue very strongly against that being the motivation. And we've seen an awful lot of stuff, obviously, with the 2020 election about elections in America and how secure they are. But what happened is disproportionately places to vote, and voter registration was changed in a way that was going to substantially disadvantage particularly some of the black communities in areas of the states. There were arguments about whether the reasons for the act being created in the first place, where there had been mass suppression of the black vote and there had been segregation, those things obviously were argued to no longer be the case, and therefore this oversight overstate an area of state control was no longer needed. Riley versus California of 2014. This is linked to the 4th Amendment, and the idea of this is protecting people from unwarranted searches of their mobile phones by the police. Now, obviously, this is something that isn't covered by the original Constitution, because the founding fathers didn't have mobile phones in which they had enormous amounts of personal data in their pocket. It's really unusual in that it's a unanimous judgment, 9-0. Now, you'll see an awful lot of the cases we look at are controversial ones where it's 5-4. This one's 9-0, which shows a kind of agreement across the different parts of the court. It's a really good example to illustrate this application of the Constitution to the modern world. An interesting in interpretation here, where a phone was seen like a locked filing cabinet at home where you had kept all these important documents, rather than being the wallet in your pocket, which the police would have the right to look at without a warrant. So again, it's interesting, and it is a really good way of illustrating the idea of a living constitution in a way where things have to be updated as the world changes. Obergefell versus Hodges 2015. This is again a really important case. Now this case is to do with gay marriage, and it forced a lot of states to change their policy, because it enshrined and gave a constitutional guarantee to gay marriage across all areas of the United States. It'd only been legal in 36 of the 50 states before this judgment, and it did this based on the 14th Amendment. Now, the split was 5-4. Justice Kennedy wrote the majority opinion, whilst Roberts, and remember this is the Roberts Court, wrote the dissent, in which he argued the court was exceeding its powers, and this decision should have been left to Congress and to the states. So it is a controversial one. Obviously, this is being celebrated as a great move forward in terms of LGBTQ+ rights, but it's one where there's a concern again over this idea of the court making law, the court, what's called judicial activism, or legislating from the bench, and so that was kind of some of the concerns Roberts was raising. Whole Women's Health versus Hellerstedt 2016. This is a really important one. It overturned some Texan state regulation that had led to the closure of numerous Texan abortion clinics, actually the majority of them. Judgment again based on the 14th Amendment, and was seen to be causing an undue burden on women, and therefore being discriminatory. It also impacted not only on laws in Texas, but laws in Mississippi and Wisconsin as well. It's a 5-3 judgment, so again the court was split, and again Roberts was in the minority. But he would go on to uphold the precedent set in this in a judgment rejecting some Louisiana regulations and laws in 2020, which again shows that in terms of the court, Roberts very much in favour of a degree of restraint and in what the court was doing, but he doesn't control the court completely. Obviously, he's the Chief Justice, but he was often being voted against, and I think this is a likely to be an area the Supreme Court is likely to return to, and the balance of the court is now different. Now, the next one, Bostock v. Clayton County 2020. Now, this is another great advancement in LGBT rights. So a really important case, and what it did is it expanded the protection in law for in employment given in the 1964 Civil Rights Act to include gender identity and sexual orientation. It was a 6-3 judgment, and the majority opinion was written by Gorsuch, who was appointed by Trump, and this therefore would be seen as a conservative justice, and so this might be seen as with a degree of surprise. And it's a huge breakthrough for LGBT rights. Now, again, there's this worry about this is the court is becoming too proactive. It's making law rather than leaving the lawmaking up into to Congress, and so this was seen by those who dissented as again legislating from the bench. So again, some really significant laws there, and some that again we can reflect on when we look at some of the theories in a second. So I've mentioned this a few times already, but I just want to kind of really pin down what it is this idea of judicial activism. So judicial activism is when judicial decision making is used to promote what are seen as desirable social outcomes. Now, this can include, or areas which can be included in judicial outcomes, are when judicial justices use their own views and values in making a judgment in terms of furthering what they see as their own social or political ends. It's also in terms of judicial activism is seen whenever a court overturns the actions of other political institutions. So it overturns an act of Congress, or it overturns state law or state regulation. It's also seen as judicial activism when a case is made that kind of ignores or overturns the precedent set by previous courts. So the second of these is probably not enormously controversial. I mean, there's a degree in it because you've got a non-elected body overturning a law made by an elected one, but you would expect the court to do this because that's its job. and that goes all the way back to the very origins of the Supreme Court. Its job is to protect the Constitution, to stop things being done that break the Constitution. And the third of them, the one in terms of overturning precedent, that tends to only be done, in fact, with really major consideration. So one of the most famous examples of that going back in time is Brown versus the Board of Education, which overturned Plessy Ferguson from the 1890s. And so again, if it's a real, tends to be quite a breakthrough case if you've got something where it's overturning earlier precedents. The first of the three, however, is highly controversial, and this is seen, as I've mentioned a few times, this idea of legislating from the bench. Now, the problem with this is you can go, oh well, they're bringing in they're bringing these liberal or conservative ideas from the bench. They're making law on this. It should be left to Congress. But often it happens when Congress has failed to make a judgment, and this is one of the reasons why it's ended up in the Supreme Court, or really it just becomes a term that people throw around a bit, and this is the bit that makes it difficult to unpick. And this is one of the bit where we always have to kind of check our internal bias on these things when we're looking at them. So do you tend to see something as legislating from the bench when the decisions that are being made are ones that you don't agree with, rather than you see all decisions which are based on promoting perceived desirable social outcomes as being wrong, whether you agree with them or not? And so this accusation of judicial activism tends to come from whichever side has essentially lost out on the judgment. So liberals might attack the legislation from the bench over gun control that we saw earlier, whilst conservatives might attack it over gay rights or abortion. So you kind of, the abortion case we saw, so you might get it from either end. Now, in terms of that part of it, it's difficult therefore to completely unpick. And what we tend to looking for is a degree of consistency. So some examples of judicial activism. Well, the most famous one is the Warren Court of 53 to 69, and that seemed to fundamentally change the position of civil rights in the USA. So we saw rulings such as Brown versus Board of Education and Miranda versus Arizona. These significantly shifted civil rights in the US, and they are still absolutely fundamental in America today. And so the Warren Court did a kind of really important case in terms of promoting socially desirable outcomes. We can see with Roe versus Wade going back to 1973, which declared abortion a constitutionally protected right. This has had a hugely significant impact because that degree of activism has then essentially become embedded, and so you then need another example of very strong activism to overturn it, because it's then become precedent, and therefore if you're not got an active court or a strongly active court, then they're likely to stick with that as the precedent, and they might work around the edges of it, but they're not going to fundamentally remove it. Another major example of judicial activism is Bush versus Gore in 2000. And in this effectively, you can argue the Supreme Court decided the election in favour of Bush. Now, the Roberts Court is an interesting one because it can be seen to have been activist over some issues. So, for example, over campaign spending, it passed some judgments based on the First Amendment, which can be seen as being kind of actively conservative in its interpretations. But over LGBT rights, it can be seen to have been rather liberal and quite actively liberal. Now this is particularly interesting because it's gone against the wishes of the Chief Justice, which is Roberts. So whilst Warren in the Warren Court the Chief Justice was seen as driving this kind of liberal action, this kind of proactive activism in terms of bringing about civil rights, Roberts actually in a way has been there writing minority opinions and raging against the majority view when it's come to the expansion of LGBT rights. And his argument on that is that it should have been left to Congress to sort this out. It shouldn't have been done by the Supreme Court. Now the court has become more strongly conservative, then possibly you can argue it would become more judicially active in favour of conservative causes, and create, again, what ideas they would consider to be socially desirable. That might not actually be the case given the stance of Roberts, but that will be, again, an interesting thing to look at. But with a 6-3 balance, even actually without Roberts, it wouldn't make a huge difference. So the opposite of judicial activism is a judicial restraint. And again, I've mentioned this, and Roberts, I think we'll look at in more detail, is quite a good example of somebody who largely stands by that as an idea. So in judicial restraint, what happens is that the Supreme Court will defer to the executive and legislative branches because they're elected, and again, that seems to make sense. And they put great store in the precedents set previously by court's judgment. And this is called stare decisis. Excuse my Latin. It is a legal principle that judges should look past the precedent, and they should essentially let the decision stand. So that then ingrains some of the ideas, and even though I mentioned this before, at the time they were made, there were examples of judicial activism, but now judicial restraint kind of ingrains them. So Roe versus Wade on abortion can be seen as one of these. Now, it's possible that some of them we've looked at today in terms of ones from the Roberts Court, DC versus Heller, and Bostock versus Clayton County. Now, both of them could be seen as degrees of activism, one on one side, one on the other. So in terms of, we've got DC versus Heller instilling the idea of the self-defense interpretation of the Second Amendment, and then we've got the Bostock versus Clayton County, which is extending employment protection over gender identity and sexual orientation. So if we now see a period of judicial restraint, then those ideas essentially become built in. They become part of the Constitution, and then any decisions are made on those areas should look back at those judgments, and they would stand. Now, one of the problems with judicial restraint is if it inherently puts bad decisions in place and then holds them up, and there are some major examples of this going back. I mean, Plessy-Ferguson, which enshrined the idea of separate but equal, and therefore upheld the idea of segregation in 1896, is a good example of this. You could look even further back to 1857 and look at the Dred Scott case. Now, so holding solidly a decision forever, it kind of, to me, seems to self-defeating for the Supreme Court. It kind of takes the power of judgment away from those justices. In other ways, you can see that it's going to protect those things and stops it against just the swings of public opinion at any given point in time. Judicial restraint is often called judicial deference because they are deferring their decisions to the elected branches, and that really can be seen as a great strength of judicial restraint in some ways. Really it is the elected branches that should make the decisions, but that idea of deference, again, it undermines the power of the court. Now, Roberts is quite a good, or the Roberts Court is quite a good way of illustrating judicial restraint, and Roberts has argued in favour of it, and again, there's some good illustrations that he's not just words, that he genuinely means it, and one of the best examples of this is the fact that he upheld the Whole Women's Health versus Hellerstedt decision as a precedent in a case involving some abortion regulations in Louisiana in 2020, even though he actually dissented on the decision in the initial case and to a degree in the second one. But he went, well, the precedent is that this is the case, and therefore that should be our judgment. And therefore he's following through with the idea of judicial restraint. He attacked the majority verdict in the Obergefell versus Hodges in 2015 and the Bostock versus Clayton County in 2020. So these were both cases which promoted LGBT rights. Now, he saw these as examples of judicial activism, of overreach, as legislating from the bench. And he argued that these ideas, these principles, should be settled in Congress and not settled from the Supreme Court benches. and in that he received a lot of support from the political conservatives who saw this as being right, and they go against judicial activism in the way that he would argue. But interestingly, if we look at some of the other ones, so for example, his refusal to overturn the Affordable Care Act, well, again, that is judicial restraint. So Roberts on this is consistent, but on that case, he faced criticism from many political conservatives, just as he received political criticism from the conservatives over the judgment involving Louisiana in 2020 regarding abortion. But he received praise for restraint when it came to his dissenting views on Bostock and the other LGBT cases. So he is fairly consistent in terms of constraint. Now, constraint is generally seen, judicial restraint is generally seen as a conservative upheld idea, not exclusive, but it tends to be more associated with it. What's interesting is when he gets political criticism for it, when he applies restraint, but does it upholding liberal ideas. So if you apply these basic principles that we've seen today in terms of judicial activism, judicial restraint, and how the court has been acting in public policy over more recent years, then yes, there is now a 6-3 conservative leaning. But if the Conservatives follow the lines of Roberts in terms of the idea of judicial restraint, then actually we probably aren't going to see massive shifts in terms of policy. Now, I may well be wrong on this, and this is, again, it's an interesting thing. It's this part, again, it's opinion, it's how you look at it. But there is a great desire amongst some groups in the US to see Roe Wade overturned. Well, that wouldn't fit with the ideas of judicial restraint put forward by Justice Roberts. Now, again, he's one justice and there's 9, and therefore it might be something that comes out in cases going forward. But it is an interesting stage in the Supreme Court in the US, and we see that actually a united court is an incredibly rare thing. So I hope that's given you loads of examples and loads to think about. If you've liked it, then please hit the like button. If you've any comments, then please leave those below. And if you haven't done so already, please subscribe and turn on notifications, and you'll find out as I make a load more US politics videos and A-level politics videos in general. And then I've also got a variety of playlists looking at different bits of British, European and American history. Thank you very much for watching.